everyone, and welcome back to the Today in True Crime and Portraits podcast. I'm your host, Jane Flowers. Today's episode is a true crime story about my mother, Brenda B Flowers, and her estate my sister and I were trying to get an accounting of. Her estate was controlled by the executor of her estate, who was my little brother, Knox Flowers, and attorney Floyd Melton III. Currently, my little brother, Knox Flowers, is incarcerated in Hattiesburg, Mississippi, for shooting someone in the leg last year. His bond is $50,000, and he can't pay it. So I guess he will just have to sit there until his court case is done and he is sentenced for his crime. The reason that my sister and I were trying to get an accounting of our mother's estate is because we deserve an accounting, and we wanted one because we know the attorneys over her estate were mishandling it. They misappropriated and mishandled her estate in many ways, but one of the ways they mishandled it was by leaving it open 10 years after our mother's death. I speak about my mother and her death on episode 5 called Getting to Know Organized Criminal Dr. John Trotter. You're more than welcome to go and listen to the episode if you want to know more about how and when my mother died of a heart attack while under the care of the attorneys at Melton Law Firm from Greenwood, Mississippi. My mother was involved with identity theft with the attorneys over her estate, and she died while under the care of attorney Floyd Melton III, his brother-in-law, Dr. John Trotter, on August the 25th, 2006. My sister originally started our court case in the Chancery Court of LeFlore County, Mississippi, and we appealed their decision all the way up to the Court of Appeals in Jackson, Mississippi. My sister Claire filed a petition with the Court of Appeals in Jackson, Mississippi, because she had tried in vain for 10 years to get an accounting of our mother's estate with no avail. The Court of Appeals case number for the accounting of my mother's estate is number 20-CA-00800-COA. In the end, the Court of Appeals granted my sister and I an accounting of our mother's estate. The Court of Appeals ruled on February 6, 2018, that my sister and I deserved an accounting of our mother's estate. The Court of Appeal judges that ruled on our case are Griffin, P.J., Carlton, and Greenlee. Our attorney representing us with our Court of Appeals case was David Neal McCarty. The appellants in the case were attorney Floyd M. Melton Jr., Floyd Melton III, and Richard Oakes. If you would like to watch the court proceedings, I have it on YouTube on my YouTube channel called Judicial Corruption of Mississippi. The video is called Claire Flowers and Jane Paxio vs. Knox Flowers and Melton Law Firm in the Court of Appeals. You're more than welcome to go there and watch the complete video if you'd like to know more about the court proceedings, in case there's something that I didn't mention here that you might hear on the YouTube video. I would like to now go over the findings in our case and if you would like to read about our case, you can read about it on the internet at caselaw.findlaw.com. My sister and I appealed the judgment of the Floyd County Chancery Court because they denied our request for an accounting of our mother's estate and customary trust of our mother, Brenda B Flowers. We wanted to know what money was going in and out of her estate because we knew her estate was mishandled and misappropriated. My sister fought for years in court filing petitions and motions only to have them thrown out by the judge over her case. One judge that threw out many a petition by my sister is Judge Ward. He dismissed them all, stating that my sister and I had no standing in this cause, nor are we beneficiaries of our mother's estate with standing to seek any relief from the estate. He concluded that the only persons that had vested interest in the administration of Brenda's estate were Knox, Drake, and Drake's adoptive parents, the Langs. As to Drake's testimony trust, Judge Ward found the trust was never funded due to the estate not being of sufficient size. Attorney Floyd Melton III left my mother's estate open 10 years after my mother's death. After many pleadings by my sister for an accounting, the assets in her estate were eventually depleted to the point that the trust couldn't even be funded. Meanwhile, Floyd Melton Jr. and Floyd Melton III were very aware that they had helped my mother with identity theft and embezzling from my trust fund. I have a breach of fiduciary with my trust fund, and my mother was involved with the breach of fiduciary with the attorneys I just mentioned. Unfortunately, I and my sister were unaware that our mother was involved with my breach of fiduciary I have with my trust fund during our Court of Appeals case and during the Mississippi Supreme Court hearings with our case. As well, we had no idea that our mother was involved with identity theft until after the ruling on our case in the Mississippi Supreme Court on March the 3rd, 2019. I didn't find out about my mother that she was involved with identity theft until around December 2019, when I did a search with the Department of Treasury under her name and another person's Social Security number that she used to open up a fraudulent bank account with Trustmark Bank with the help of attorney Floyd Melton Jr. And afterwards, she cashed out my World War II Series E bonds that I had within my trust with the Department of Treasury under her name and this other person's Social Security number. This other person was very aware my mother was using her social and was very compliant the whole way. The reason that attorney Floyd Melton Jr. and Floyd Melton III refused to give an accounting of our mother's estate is because of the fact that she is involved with identity theft with them and they know it. They can't let us have an accounting of her estate on those grounds. But believe me, they're not going to tell you that. Instead, Judge Ward found out that my sister and I had no current interest in our mother's estate. My sister would later appeal the court's denial of her motion for leave to amend several of her previously filed petitions. Upon review, the Court of Appeals affirmed the Chancellor's denial of Claire's motion to amend her petitions. However, they found that Claire and I have limited rights and related standing as holders of a shifting executory interest to prevent future waste, and therefore they found that my sister and I have standing to request an accounting of our mother's estate and customary trust pursuant to our limited rights. As a result, the Court of Appeals reversed the portion of the Chancellor's judgment denying their request for an accounting and remanded our case for further proceedings consistent with this opinion. The facts in our case were that Richard and Brenda Flowers married and had 3 children, Knox, LeMay Flowers, and 2 daughters, Claire and Jane. In 2004, Claire gave birth to her son Drake. Then Richard and Brenda adopted Drake in 2005. On April 15th, 2006, Richard passed away from lung and kidney cancer. About 3 months later, on July 24th, 2006, Brenda executed her last will and testament. Almost a month later, on August the 25th, 2006, Brenda passed away. Brenda's new will was filed 2 weeks after her death, and Knox was appointed executor of her estate and provided that he serve without bond, inventory, appraisal, or accounting to any court. None of the beneficiaries of my mother's estate were contacted originally when the change of executor of her estate happened. So they, the beneficiaries, if needed, could appeal the appointment of executor to her estate. But, of course, Melton Law Firm deliberately never contacted the beneficiaries in the beginning. So, if needed, they couldn't contest the appointment of Knox as executor of my mother's estate. Now, mind you, remember where my little brother is currently residing? He's incarcerated in Hattiesburg, Mississippi, for shooting his friend in the leg with a gun. This is the executor of my mother's estate, who is by law not allowed, if he doesn't want to, give an accounting of my mother's estate to the court. Wow! No accounting. That means Attorney Floyd Melton Jr. and Floyd Melton III could do anything they want with my mother's estate and get away with it easily because they don't have to give an accounting ever. How convenient for the attorneys involved with the identity theft with my mom. How convenient indeed. My mom's will also established a trust that named my sister's son, Drake, and his descendants as the income beneficiaries. Her will provided for the trust termination either at the time of Drake's 13th birthday or his death, whichever event occurred first. Her will further stated that at the time of termination, the trust assets were to be divided evenly between Drake and Knox. But before this could happen, on May 6, 2016, Judge Ward signed a final decree and rafted Knox's final accounting of my mother's estate and granted his petition from discharge as her estate's executor. I guess Knox got scared when my sister and I went to the Court of Appeals to get an accounting, and he wanted out. To tell you the truth, I'm not really sure why he wanted out as executor of my mother's estate, but I'm sure her being involved with identity theft and the fact I and my sister were trying to get an accounting of her estate had a lot to do with that. My mom's will also granted Claire and I shifting executory interest by providing that if both Drake and Knox passed away without any descendants before the trust termination, then the trust assets were to be distributed to Claire and I as beneficiaries, either directly or through conservatorships. While her will relieved the trustees from having to render a periodic accounting to any court, it stated that the trustees shall account fully and completely annually throughout the term of this trust to such income and or corpus beneficiaries as there may be, or in the event such beneficiaries is a minor or a ward, then to such beneficiaries' guardian. A month after my mother's death, my little brother, Knox, was appointed executor of her estate, and in November of 2007, the Chancery Court awarded custody of my nephew Drake to his parental grandfather and step-grandmother, Carter and Linda Lang. In a subsequent judgment, the Chancellor found that the adoption by the Langs served Drake's best interests. My mother's will established the trust assets vested in Drake and Knox. Their interest shifts to my sister and I only after the natural termination of Drake and Knox is a state, and only if Drake and Knox died with no descendants. The end result in the ruling by the Court of Appeals for the accounting of my mother's estate was affirmed in part, reversed, and remanded in part. The Court of Appeals stated that all good things must come to an end in Jane and Claire's case, and it was time for a bad thing to come to an end. The Court of Appeals agreed with the majority's finding that no abuse of discretion arose from the Chancellor's denial of Claire's Rule 15 motion to amend, but they did disagree with the majority, finding that the Chancellor erred by denying Claire and Jane a request for an accounting of the estate and testamentary trust of our mother. The courts affirmed the Chancellor's judgment, bringing our case to an end in the Court of Appeals. They concurred in part and dissent in part from the majority's opinion. After the Court of Appeals' final judgment that my sister and I have standing to request an accounting, finding that we had limited rights as holders of a shifting executory interest to prevent future waste, attorneys Floyd Melton Jr. and Floyd Melton III would later appeal their decision to the Mississippi Supreme Court. They petitioned the Mississippi Supreme Court for a writ of certiorari, claiming that Claire and Jane's appeal was untimely and that the Court of Appeals misapplied case law related to shifting executory interest and standing to request an accounting. The docket number for the Mississippi Supreme Court case is number CT-00800 SCT. The case is in the matter of the estate of Brenda Louise Vargas Flowers, Claire C. Flowers, and Brenda Jane Flowers Baxio versus the estate of Brenda Louise Vargas Flowers through its executor, Knox LeMay Flowers, Cecil C. Lang, and Linda S. Lang. The Mississippi Supreme Court stated in their final judgment of our case that the Court of Appeals ruling in our case was affirmed in part and reversed in part. The judgment of the Floyd County Chancery Court was reinstated and affirmed on March the 7th, 2019. The summary of the case is that Claire Clements Flowers, Claire, and Brenda Jane Flowers Baxio, Jane, appealed a Chancery Court judgment denying their request for an accounting of the estate and testamentary trust of their mother, Brenda Vargas Flowers. The Chancery Court concluded that the daughters did not have a current interest in their mother's estate. On appeal, the daughters argued that they were specifically named in the will to be remainder beneficiaries and thus have standing to request an accounting. The Court of Appeals found that Claire and Jane had standing to request an accounting from limited rights as holders of a shifting executory interest to prevent future waste. The estate petitioned the Mississippi Supreme Court for a writ of certiorari claiming that Claire and Jane's appeal was untimely and that the Court of Appeals misapplied case law related to shifting executory interests and standing to request an accounting. The court granted certiorari not to determine whether Jane and Claire had standing, but it is agreed that they did, but to determine whether the Chancellor abused his discretion in denying the sisters an accounting request. The court found no manifest error in the Chancery Court's decision to deny Claire and Jane's request for an accounting and reverse that portion of Court of Appeals judgment. The court reinstated the Chancery Court's decision denying Claire and Jane's request for an accounting. Then the judgment by the Court of Appeals was affirmed in part and reversed in part. The Supreme Court ordered that judgment reinstated and affirmed in the Floyd County Chancery Court on March the 3rd, 2019. During my sister's and I's court hearing with the Mississippi Supreme Court, Attorney Floyd Melton III's father-in-law, Cham Trotter, held a meeting with the Mississippi Supreme Court Justice in regards to a photo that was donated to the Mississippi Supreme Court in the middle of my sister's and I's court proceedings with his family members. He donated this photo to the Mississippi Supreme Court's archives on September the 5th, 2018. Cham Trotter's daughter is Lisa Trotter Melton. Lisa is married to attorney Floyd Melton III and his son, Dr. John Trotter. Dr. John Trotter was my mother's doctor when she died of a heart attack on August the 25th, 2006. Cham Trotter was one of the people that attended a meeting at the Mississippi Supreme Court on September the 5th when a photo composite of the 1902 and 1903 Mississippi bench and bar was donated to the Mississippi Supreme Court's archival collection, with Cham stating at the meeting that the composite is one of the only three known to exist, that he has one in his Belzoni office. He also stated that his great-grandfather, Justice William Campbell McLean of Grenada, is among those in the composite, while stating that the composite is arranged alphabetically by town. Attorney Richard Edmondson was one of the few that attended the meeting, and he stated while at the meeting he found the composite stored in the back room of his mother's McGee home when the family began preparing it for sale. The judges that attended the meeting to receive the display into the Mississippi Supreme Court were Chief Justice Bill Waller, Jr., Presiding Justice of the Mississippi Supreme Court, Jim Kitchens, Mississippi Supreme Court Justice Leslie King, Mississippi Supreme Court Justice Josiah Dennis Coleman, while they all joined Chief Justice Waller for the viewing of the composite. Well, it looks to me there might be some racketeering going on here. Oh my, do I see names of judges that were involved with the ruling of the accounting of my mother's estate that attended the viewing of this composite at the Mississippi Supreme Court? Well, isn't that interesting, and how convenient, too, that they would reveal the composite photo during my sister and our court hearing. How convenient indeed. Well, since we all know that Cham Trotter is related to one of the attorneys in my case with the Mississippi Supreme Court, then do you all think that possibly Cham spoke to the judges and asked them not to rule in our favor? Who's to say, really? But I sure wonder if that was the case. How can one not wonder if that was the case, since my mother was involved with identity theft with attorney Floyd Melton Jr. and his law firm? How about Chief Justice Leslie King? He's from Greenville, Mississippi. That's right in the Delta now, isn't it, where my case originates? Associate Judge David M. Ishii of the Mississippi Supreme Court is no stranger to Cham Trotter either, which would mean that there could be a conflict of interest with David ruling within the Mississippi Supreme Court on my case for the accounting of my mother's estate on the grounds that he knew and he was friendly with Cham Trotter. How could he not be? I want to point out to you all that I suspect Mississippi Supreme Court Judge David Ishii could have a conflict of interest in his ruling on my case in 2019 for the accounting of my mother's estate within the Mississippi Supreme Court. I found on the internet an ad for the Mississippi Gulf Coast Legal Professional Association dated July 31st, 2017 that stated Cham Trotter attended an event with other attorneys, paralegals, and other paraprofessionals with Mississippi Supreme Court Judge David Ishii. This ad I found on the internet fuels my suspicion that they could know each other and be friends. Therefore, it would be a conflict of interest for him to rule on my case within the Mississippi Supreme Court for an accounting of my mother's estate. I'd like to go over now the event that Cham attended with David in Gulfport, Mississippi, July 31st, 2017. The event began at 8 a.m. and ran all the way up to 5 p.m. with William Tram Trotter III representing the Mississippi Bar Committee on professional responsibility. He spoke that morning about ethics and professionalism going hand in hand. Cham Trotter is an attorney at Gerard and Trotter in Belzoni, Mississippi, and he's also the father to Lisa Trotter Melton and the father-in-law to attorney Floyd Melton III. Shortly after Cham spoke at 11 a.m., that same morning, the Honorable Judge David M. Ishii with the Court of Appeals, District 5, Position 2, spoke about appellate procedure. David M. Ishii is no stranger to the Mississippi Gulf Coast Community College by any means. As a matter of fact, he served for 2 years as an adjunct professor teaching at the Mississippi Gulf Community College. He taught torts and personal injury law. Now, do you all think that David and Cham don't know each other? Do you all think that they didn't see each other at this event and hang out and talk to each other? I would guarantee it that they did see each other at this event and hang out as well. David M. Ishii was one of the judges in the Mississippi Supreme Court that ruled against my sister and I getting an accounting of my mother's estate. But regardless of his ruling, I will still be able to get an accounting of her estate on the grounds that she was involved with identity theft with the attorneys that control her estate. Because once I start my case for my breach of fiduciary I have with my trust fund, or whichever comes first, let's say the attorneys that were involved with the breach of my fiduciary are charged with racketeering, money laundering, embezzlement, and identity theft before I'm able to retain an attorney. Whichever comes first, I am completely fine with. How many of you think that the judges that ruled on my case with the Mississippi Supreme Court are Freemasons? I know for a fact that there are quite a bit of Freemasons that are in the Supreme Court of the United States. How many of you know that some of the people that are going to be indicted with my case are also Freemasons? They most definitely are. Do any of you think that these people look after each other and make sure that they don't get in trouble if they can and have it within their power to do so because some of them are Freemasons? I would think so. I will probably never know if any of these judges that were ruling over my mother's case for the accounting of her estate were colluding together. These judges and attorneys have no shame. The end result for some of the corrupt individuals involved with the attorneys in the accounting of my mother's estate is that they will also face racketeering charges. Believe me, I'll make sure they do. Attorney Floyd Melton Jr. and his son Floyd Melton III are running a criminal enterprise and the judicial system in Greenwood, Mississippi, while using my mother's name with identity theft. Racketeering is a felony punishable up to 20 years in prison. Forgery can be 14 years in prison, and when you've got identity theft, you've got a lot of forgery going on right there. Attorney Floyd Melton Jr. and Attorney Floyd Melton III abused the trust of the system that puts attorneys first when they got involved with identity theft and the embezzlement case I have with the breach of fiduciary with my trust fund. All the attorneys that are going to be indicted with the breach of fiduciary I have with my trust fund are also going to be indicted on racketeering charges because they've all been working together running a multi-million-dollar criminal enterprise in the Mississippi Delta. These attorneys swore an oath to the Constitution to take their clients' interest above all others. They represent their clients in court, and since they are an officer of the court, they are held to a higher standard than the average person that appears before the court. It is not a privilege to be an officer of the court. It's an obligation to be an officer of the court. And Attorney Floyd Melton Jr. and Floyd Melton III have failed miserably to uphold the obligations to the court because they are all involved with racketeering, and any other judge, doctor, accountant, attorney, or civilian that has been helping them over the past 20 years launder money are going to be convicted right along with them on racketeering charges. Because believe me, I'm going RICO all the way on these career criminals. Your days using my mother's name with identity theft are over. I'm going to end this episode here. I hope you were all able to clearly understand from my observation and me stating so in this episode what's going on with my breach of fiduciary I have with my trust fund and my mother's estate that was mishandled by Melton Law Firm in Greenwood, Mississippi. If there's anything you did not understand in this episode, then could you please comment in the comment section if you have any question for me about my episode that you need clarity on? Thank you for listening. Please subscribe and leave a comment. I'll see you next episode. Until then, goodbye everyone.